Yes, leave granted.
Lordship, may I have also same prayer, Your Lordship. I want to file an appeal which is without certified copy, Your Lordship.
All right, leave granted.
Grateful, Your Lordship.
Appellate side, daily listed matters. Under the heading for judgment, item number 1.
I am for the appellant, my lord.
Yes. In the light of the above, we hold that the appellant has not made out any case for interference with the order passed by the learned single bench. Accordingly, the appeal is dismissed. The direction issued by the learned single bench in paragraph 49 of the impugned order shall be complied with within a period of 3 weeks from the date of receipt of the server copy of this order.
Lordship, great.
Sir, we can upload the order only on Mondays. On Monday. There's some inconvenience today. On Monday, first thing in the morning, they will upload.
Lordship, I am grateful.
Right.
Item number 2.
I'm for the
writ petition. I'm not respondent number 5.
My lord, I am
Yesterday's matter.
appellant.
Yesterday, my lord, your lordship heard this matter, my lord, and fixed today.
Yes. Yes, yesterday your lordship was asking some clarification. You please clarify.
Yes, my lord, I have taken, my lord, my lord Justice Bhattacharya's, my lord, query, my lord, regarding the appellant, my lord. Some of the 2 of the plaintiff is being joined as an appellant in this appeal.
Former defendant in the said writ petition, my lord.
Yes, they were the pro forma since, my lord, my 2 brothers was living in Patna. My lord, in my writ petition, I have made, my lord, my 2 brothers, the other plaintiff as pro forma respondent in my lord, writ petition. Here, my lord, they have been joined as appellant. My instruction, my brother never executed any vakalatnama in favor of the present appellant. Seeking for incorporation of the
page number 46.
Yes.
Of the said annexed writ petition. My lord, here is the said judgment. My lord, the said scheduled property A of the said suit is a joint property.
What is the ground of challenge to the impugned order? And the got passed. What are the grounds of challenge to the impugned order?
My lord, here the said civil suit, one civil suit by the other co-owner has been filed, which is I have annexed in page number 92 of the state application. That is Meena Devi, Biltu Paswan, Laxman Devi, Shital Devi, Sujata Maji, Songita Maji, again the present appellant on the same schedule A and B of the previous title suit, and the learned trial court has given injunction in the said suit, my lord.
Yes.
And said execution order is under challenge in a CO case before the Honorable Justice Shampa Sarkar, which is not yet been heard.
Against which order?
My lord, the execution order passed by the learned trial court, my lord.
What is the date of the order?
My
Have
lord,
you annexed that in the writ petition? In the stay application, where is that?
page number 80, 81, 82 and 83, my lord. My lord, where a miscase, the said degree for which the execution has arisen, there is a miscase filed, miscase 86
Yes,
for vacating and set aside of the said degree.
this miscase is pending.
Yes, my lord. And in that miscase, one stay application was filed, which was turned down by the learned trial court, and for which one CO application has been prepared before the honorable court, which is still pending, my lord.
CO is against the order dated 10th of January.
Yes, my lord, it is the 10th January to 2023. CO application is
When have
pending.
you filed this?
My lord, we have filed before this writ application.
And what is the stage of that civil revision?
My lord, it is pending in the list of honorable justice.
Have you taken any steps for moving that application?
My lord,
Have you taken any steps for moving that application?
we have mentioned several times, but it was not yet heard, my lord.
My lord, even
Then
written a letter asking my lord to serve a copy of the revisional application. Till date, my lord, they have refused blatantly, my lord, to serve even the copy of the
No
revisional
letter
application.
has been given on this effect.
all right, so what is your challenge to the impugned order? Kindly come to the impugned order.
My lord,
One, you say that once title suit is pending
yes, my
by
lord.
another co-owner.
Yes, my
And
lord.
what is the ground of challenge to the impugned order?
Look, that is also an eviction suit by the other co-owner against the present appellant.
All
And
right, so,
here the learned court granted injunction against the said appellant in page number 97 of the stay application.
page 97.
Yes, my lord.
This is the letter of the advocate.
Yes, my lord.
Where is the order?
In page number 98, that all the parties of the suit along with their main and agent are hereby directed to maintain status quo in respect to nature, character and possession, and the alienation or creating any third party interest in respect of the schedule suit property as mentioned in the schedule of the plaintiff as on this date till 10 February 2023, which is extended till the date.
Is the fifth respondent a party in that suit?
No, my lord.
My lord, here Meena Devi is the other co-owner.
No, I'm asking you whether the fifth respondent, the decree holder, is a party in this suit.
No, my lord.
Yes. Anything else?
My lord, here the schedule property of that suit and schedule property of the present challenged suit is same. And
Yes.
and from this judgment, it is very clear that the ownership has not been patent or demarcated by the court.
All right. Anything else?
But it is a totally a civil suit. If the police disposes me, I have no right. The infectious of my miscase to contest the said suit, my lord.
All right. Yes, Mr. Mukherjee.
Kindly, my lord, I have nothing to, my lord, say, my lord, regarding this suit. Your lordship has already noticed. This is not my co-owners. This is a setup suit, my lord, by some third parties
No, my lord.
against, my lord, this, my lord, particular, my lord, appellant. And, my lord, there, my lord, the status quo order is no way binding on me, my lord. I am the decree holder. Till date, my lord, the decree has attended finality. Order 9, Rule 13, my lord, they have though filed. Connection with therewith, my lord, the stay application is being refused. Till date, my lord, they have not moved, my lord, the civil revisional application. And, my lord, your lordship kindly clarify regarding, my lord, the two other my brothers as the plaintiff in the suit. They have joined as, my lord, they have shown to be joined as, my lord, two of the appellant along with the present appellant. My lord, this is not, my lord, the actual scenario. My lord, I have taken specific instruction. My two brothers are living in Patna. They can come and swear an affidavit before your lordship stating that they have never executed any wakalatnama, asking, my lord, to, my lord, arrest them as an appellant in this suit. My lord, in this appeal. Kindly, my lord, clarify that situation. And your lordship knows that it is a case where I have approached every avenue of the civil court. I have, my lord, filed 208 application, contested over there, my lord, the judgment data. They have suffered and my lord, order by virtue of which police help was being granted. Twice I have deposited police cost, my lord, 1,05,000 and odd rupees. Thereafter, my lord, 3 times, my lord, it is on record before the writ court, 3 times the concerned officer in charge refused not to provide assistance in spite of the order of the learned executing court. Thereafter, I approached the Honorable High Court for the asking for police protection.
But here the
This is my
total
submission.
matter is evolved in the executing court, my lord.
But I'm sorry, my lord.
Anyone appearing for the state?
My lord, yesterday also no
Sir,
one appeared.
Them and
Okay.
the of services in the
Yes, Mr. Bhattacharya, are the other appellants signed in the Vakalatnama?
my lord, I got the instruction to add them, my lord.
Sir, in your copy, can you please verify whether the other appellants have signed in the copy? There is a Vakalatnama.
1 second, I will verify.
They will send it if it is required, my lord.
No, not they will send it. How could you file this without their Vakalatnama?
Lord, I got the instruction, my lord.
No, there is no vakalat now.
All right. So then I'm passing the order.
Yes, sir. Yes.
This appeal is at the instance of a judgment data register challenging an order dated March 20, 2023, passed by a learned single judge in WPA 5402 of 2023. System. Paragraph. By the order impugned, the Shivpur police, the authorities of the Shivpur police station was directed to deploy appropriate police force on the date and time mentioned in the said order. The bailiff of the civil court was also directed to deliver possession as ordered by the civil court on the date and time mentioned in the said order. Paragraph. The fifth respondent, along with the appellant numbers, along with
The fifth
Tapeshwar Chaudhary, along with Tapeshwar Chaudhary and Maheshwar Chaudhary, filed a title suit number 546 of 2019 before the learned civil judge within bracket senior division, third court at Howrah. The said suit was decreed ex parte on September 29, 2021. The decree was put into execution, giving rise to title execution case number 16 of 2021. First of the executing court directed the bailiff to deliver possession in favor of the decree holders. First up, however, the bailiff was resisted, and upon an application filed by the decree holders under Rule 208 of the Civil Rules and Orders, the executing court directed the Nazir to execute the decree through process server with the help of police. First up, since thereafter the possession could not be delivered, an application for breaking open the padlock was filed by the decree holder. First up, the executing court allowed such application, thereby authorizing the bailiff to break open the padlock in any of the rooms with police help. The appellant claims to have filed a miscellaneous case under Order 9, Rule 13 of the Code of Civil Procedure, being Miss Case number 86 of 2022, praying for setting aside the ex parte decree dated September 29, 2021, passed in title suit number 546 of 2019. Full stop. The prayer for stay of execution of the prayer for stay of execution at the instance of the appellant hearing, however, stood rejected by an order dated January 10, 2023. Full stop. Paragraph. The fifth respondent, pursuant to an order passed by the executing court, deposited the police cost for the purpose of obtaining possession by executing the decree. Full stop. Alleging inaction on the part of the police, the fifth respondent filed an application under Article 226 of the Constitution of India. Full stop. The writ petition was allowed by the order impugned. Full stop. Paragraph. Being aggrieved, the appellant being aggrieved, the judgment debtor / register in order to resist the eviction, resist the execution of the eviction decree, has approached this court by filing this intra-court mandamus appeal. Paragraph. Mr. Bhattacharjee, the learned advocate representing the appellants, drew the attention of the court to the eviction suit, being title suit number 65 of 2023, filed by Meena Devi and others against the appellant number 1 herein, praying for his eviction from the property. Mr. Bhattacharjee contends that the schedule of the property mentioned in title suit number 65 of 2023 is identical to the decretal property involved in title suit number 546 of 2019. He further submits that since the executing court is in session over the matter and there is a dispute with regard to identification of the decretal property, this court, in exercise of its jurisdiction under Article 226 of the Constitution of India, ought not to have interfered with the ought not to have passed the impugned order. Paragraph. Mr. Mukherjee, learned advocate representing the decree holder / fifth respondent,
But may I interrupt your lordship? May I once, Lord? I'm sorry. If your
Yes.
lordship kindly compare with page 95 and 43. 43 is my schedule of my suit,
Mr.
which was
Mukherjee, let us deliver the judgment.
but the schedule is different.
Afterwards, you hear the judgment. Actually,
I'm sorry.
Mr. Mukherjee, learned advocate representing the decree holder / fifth respondent, submits that the schedule of the that the decretal property and the schedule of the property of title suit number 65 of 2023 is different. He further submits that the decree holders of title suit number 546 of 2019 are not parties in title suit number 65 of 2023. In view thereof, the pendency of the title suit has no bearing in the execution of the decree passed in title suit number 546 of 2019. Paragraph. Heard the learned advocates for the parties and peruse the materials placed. The records reflects the following factual position. First up, the decree for eviction, though ex parte, was passed as far back as on September 29, 2021. First up, the said decree was put into execution, giving rise to title execution case number 16 of 2021. First up, the learned executing court on an application filed under Rule 208 of the Civil Rules and Orders passed an order on February 8, 2022, directing the Nazir to execute the decree through process server with the help of police. First of the executing court also passed a direction authorizing the bailiff to break open the padlock in any one of the rooms with the police help. First up, the contention of the learned advocate for the appellant, number one of the appellants, that since the title suit being number 65 of 2023 is pending, the writ court ought not to have passed the impugned order, cannot be accepted for the following reasons. Firstly, as would be evident from the schedule of the property of title suit number 65 of 2023, the subject matter of eviction is a first floor flat at holding number 60 Kaji Soiful Alam Lane under police station Shibpur, whereas the decretal property is a self-contained residential flat within Howrah Municipal Corporation holding number 61 Kazi Safiul Alam Lane. It is therefore evident that the properties involved in title suit number 65 of 2023 is not same and identical with the decretal property of title suit number 546 of 2019. That apart, the decree holders of title suit number 546 of 2019 are not parties in title suit number 65 of 2023. Therefore, the pendency of title suit number 65 of 2023, as well as any orders passed in connection thereto, cannot have any bearing on the, cannot have any impact on the execution of the decree passed in connection with 546 of 2019. First up, now the question arises as to whether the writ court could entertain a writ petition praying for a direction upon the police to implement the order passed by the civil code. So, paragraph. Article 226 of the Constitution of India states that the High Court shall have the power to issue to any person or authority, including any government, directions, orders or writs, including writs in the nature of habeas corpus, mandamus, prohibition, quo warranto, and certiorari, or any one of them, for the enforcement of any of the rights conferred by Part 3 and for any other purpose. It follows therefrom that the first part of Article 226 of the Constitution empowers the High Court to protect the to pass orders, directions, or writs for the purpose of protection of the fundamental rights. The second part of Article 226 within bracket 1 empowers the High Court to enforce the legal duty of any person or authority. Full stop. The expression within double inverted comma for any other purpose, inverted comma closed, used in Article 226 within bracket 1 of the Constitution has been interpreted by the Honorable Supreme Court in the case of Calcutta Gas Company within bracket proprietor bracket closed limited versus State of West Bengal, reported at AIR 1962 Supreme Court 1044, to mean the enforcement of any legal right and the performance of any legal duty. Full stop. It is not in dispute that the police authority is under a legal duty to obey and or enforce and implement the orders passed by the civil court. Full stop. Merely because of the fact that an execution case is pending, that cannot, however, curtail the power of the High Court under Article 226 of the Constitution of India to issue a writ or direction to the police authority within the state to enforce the order passed by the civil court. Therefore, in our considered view, the learned single judge was perfectly justified in was right in entertaining the writ petition at the instance of the decree holder for the purpose of issuing direction upon the authorities of the Shivpur police station to deploy appropriate police force. First up, it is not in dispute that the decree holder / fifth respondent herein has already deposited the police cost over police cost amounting to rupees 1,05,761 as submitted by Mr. Mukherjee, learned advocate for the petitioner. First up, in view thereof, the order impugned is not interfered with by this court. However, since the time within which the order passed by the executing court for delivery of possession with police help has stood expired for the reasons as aforesaid, the time for the time stipulated by the learned single judge for deployment of appropriate police force is extended for a period, is extended till till August 25, 2023. Till 4 p.m. of August 25, 2023. Full stop. The Commissioner of Police, Howrah Police Commissionerate, being the Commissioner of Police, Howrah Police Commissionerate, or the only Howrah, respondent number 2 or 3?
Howrah Police Commissionerate.
Howrah Police Commissionerate.
Yes, Milord.
কি বললাম? The Commissioner of Police, Howrah Police Commissionerate, is directed to issue appropriate instructions to the officer in charge, Shibpur Police Station, being the 4th respondent in this appeal, to deploy appropriate police force in terms of the direction passed by the learned single judge. Full stop. The appeal stands disposed of with the modifications as indicated herein before.
Milord, one thing, Milord, kindly
Yes.
see page number 43, the same schedule, Milord. To page
Acha,
number
at likhun,
number 95.
since it is since a
All-
miscase,
it-
since
it-
the miscase being
All- the same
uh,
problem, first floor of
since
this.
the miscase being number 86 of 2022 is praying for setting aside of the ex parte decree dated September 29, 2021 is still pending, comma, this court makes it clear that the applicants in the said miscase will be at liberty to take appropriate, will be at liberty to avail of the remedies under the Code of Civil Procedure in case the said miscase is allowed by the competent civil court.
Milord,
extremely good.
one thing, Milord,
There
in
shall be, however, no order as to cost urgent photostat certified copy.
I'm extremely grateful.
same, Milord, here the property is same in the first floor of the same address in both the
Yes, Mr. Bhattacharyji, we have dictated our order.
Item number 3,
Yes.
Lordship, I appear on behalf of the appellant. Your Lordship, it was adjourned on the last occasion for the department to
Yes,
take
yes. Department to get instruction as to whether your reply
reply
was
was
received. You got instructions, but is that
Milord, it is, Milord, you have also, Milord, record, Milord, got instruction, Milord. Milord, it appears, Your Lordship, kindly see, Milord, their reply, that is, Milord, in page number, Milord, 99.
yes?
Your Lordship, got it, Milord. They have, Milord, uploaded in, Milord, in the, on 24/1/2023, Milord.
Yes.
Right hand one, and Your Lord, show cause, Milord, already passed on 23rd, one day before. Your Lordship, kindly see the show cause order, Milord, 110, show cause to the, Milord, before the, Milord, assessment order, Milord, page 110. Your Lordship, kindly see, Milord, 23rd 1/2023. Milord, before, Milord, the uploaded his partial, Milord, objection, Milord. Here in this case, Milord, he has filed objection. He has prayed for time for file further objection. Thereafter, Milord, he has filed second objection. In the second objection, he has also prayed for time. Milord, lastly, Milord, he had, Milord,
supplied, my lord, the objection, my lord, before, not before the, my lord, after the, my lord, show cause. Your lordship, your
It is
lordship,
on the same day.
and your lordship kindly, only one thing, your lordship kindly see the assessment order.
It says it is not received. Assessment order was passed only on 3rd of February,
My lord,
3/2/2023.
my lord, third of, before, my lord, the 23rd 1/2023, the show cause notice has been passed. After the show cause notice, my lord, the assessment order also passed. Your lordship kindly see only, my lord, one portion of the, my lord, assessment order. My lord, ample opportunity given to him, he has not replied. That is, my lord, appearing from the assessment order itself. Kindly see, my lord, page 134. Not, my lord, 134, 132. Your lordship got it. My lord, detailed opportunity given. My lord, 120, 142, one notice. My lord, he has replied several occasion, 2/11/2022, 7/11/2022.
Correct. So
There are
that shows, no, that shows he has been cooperating.
My
He is
lord,
not,
142, one notice, my lord, he has not replied. That is, my lord, on date of reply fixed on 16/1/2023, not received, he has not replied. 143, two notice, date fixed on 21/1/2023, he has not replied. And
no,
not,
he replied. He replied and uploaded it on 23/1/2023.
not
But
this
you issued the variation show cause notice on the very same date.
show cause notice issued, my lord, before, my lord, on 23rd 1/2023, because his
Correct.
last reply was 24/1/2023.
24/1. Okay.
Your lordship, just two things. Your lordship,
And not
Hmm.
only that, my lord, only one thing, my lord, may I, my lord, point out, because the, my lord, read code, my lord, the respondent did not appear. Because, my lord, he has made party to the respondent, my lord, they are not existing. My lord, the principal commissioner of income tax 20, my lord, there is no principal commissioner of income tax 20. And, my lord, the income tax officer ward number 62(1), that is under, my lord, PC 89. That's why, my lord, in the writ petition also nobody appeared.
But who is the other officer who passed the assessment order?
That it is the faceless officer, my lord. No, my lord, we do not know who the faceless officer, my lord, passing the
Oh.
assessment. And, my lord, only one thing, last submission before your lordship, the, my lord, show cause notice passed on 23rd 1/2023. Order and assessment order passed on 3/2/2023. My lord, he have come this court on writ petition affirm of 13/3/2023. After, my lord, 1 month, 10 days. And not only that, my lord, if, my lord, he learned, my learned faith case was, my lord, in the show cause notice, my lord, his last replied not considered, my lord, he has come at the stage of show cause notice when it was passed on 23rd January 2023. My lord, now, my lord, in the, my lord, after the assessment order passed, my lord, he has a remedy before the CIT appeal. And, my lord, to evade the, my lord, to 20% deposit, my lord, he has come before the court.
Yes, sir.
Your lordship, only three things. One, your lordship, I have the reply, the show cause notice was received by me on 23rd of January 2023, which I have replied to on 25th of January 2023. The reply is also on record at page 113. Your lordship, my reply to the notice dated 11th of, your lordship, may kindly once again take up the assessment order at page 132. Your lordship, the details of
One clarification.
yes, your lordship.
Notice was page 99. Notice was issued on 11th January 2023.
2020, your lordship.
Due date for submission was 16th of January.
Yes, your lordship. I was time.
And you have uploaded your reply on 24th of January.
Yes, your lordship, that is what it is seen. And your lordship will find my reply at page 101, though it is dated 19th of January, since my learned friend is indicating that it was uploaded on 24th of January. Lordship,
Yes,
I will take it as it was admitted on 24th of January 2023.
very
Lordship,
good.
the event, your lordship, I was delayed in filing my reply. Your lordship, be that as it may, if your lordship may kindly come to the assessment order, page 132.
No, please, you are indicating page next there is a show cause notice at page number 110.
110 is the show cause notice, your lordship. I had replied to it at page 113. Your lordship will find the acknowledgement receipt, and page 115 is the reply.
So
Lordship.
this show cause notice as to why proposed variation should not be made.
Yes, your lordship. Yes, your
And no. Yes. So the due date was on 28th January,
Lordship,
but you had given your reply on 25th January.
25th of January, your lordship will find my reply at page 115. So I've also
Yes.
replied to the show cause notice. Now, your lordship, kindly appreciate page 132, that is the assessment order. The 142.1 notice was replied to me by four letters, and your lordship, it is admitted that the response type was part. So I was to furnish further particulars, which your lordship, in my humble submission, I have done by my letter dated 19th of January, which was uploaded. Now, your lordship, the only thing remains is that it was delayed. Now, your lordship, the portal was open. Your lordship, kindly keep in mind that I am the assessee. Your lordship, I went to upload the reply. I might have been delayed. My reply was uploaded and e-acknowledgement receipt was issued to me. Lordship, my learned friend on the last occasion submitted that it was not shown on their portal to the assessment officer. Your lordship, as an assessee, your lordship, I could not have known that they have not gone through the reply. Today, only what I am asking is that please consider my reply and then pass the assessment order. Your lordship, I as an assessee could not have known that they have not seen my reply. The assessment order was passed on 3rd of February 2023. That is after my reply was filed. Lordship, the only limited prayer I'm making.
What you could have done is, in response to the earlier notice.
Yes, your lord.
See, on 11th of January, due date was 16th of January,
Yes, sir.
but you replied on 24th of January. On
Yes, sir.
25th, thereafter, on 23rd, you have received a notice under 147.
Yes, your lordship.
And you had ample opportunity to point out in your reply dated 25th of January 2023 that please consider my reply, which was uploaded on 24th, to the previous day. So that shows that the assessee was dragging on the matter from November. How many notices he can issue?
Your lordship, subject to correction, your lordship, though he must have pointed out, but in any event, your lordship is not pointed out.
Oh, yes. What is all there? You file an appeal, that will be better.
Very well, your lordship, if your lordship so directs, but your lordship, I was only on the point of grounds of violation of principles of natural justice, that if they would have passed the assessment order after considering my reply. Lordship, the amount assessment order is only for 2,30,000. The petitioner is a retired medical practitioner. Lordship, he was delayed by a few days. Though he had uploaded the reply, your lordship, he was under the impression that the reply has been uploaded, so it has been taken into note of. Lordship, at that point of time, he was not aware. Now, your lordship, my learned friend says that it was not shown in their portal, but I was allowed to upload the reply at that point of time.
Anybody will not upload the reply, he can get the acknowledgement.
Lordship, that
This
is
is the system generated acknowledgement. They can get the acknowledgement.
But he may be an individual assessee, but the property is worth more than nearly 1 crore.
No, your lordship, it's some 87 lakhs. Your lordship, he's a retired medical practitioner. After retiring, he's bought a home for himself.
Medical practitioner,
Your lordship, your lordship.
No, that's correct. But then what was your explanation?
Your lordship, I've furnished that I have taken a bank loan. Your lordship, the documents are also furnished, and the rest of the earnings was paid by my own savings. Your lordship, that is also given. Your lordship will find it in my replies. The first reply part reply that I had issued from page 41 onwards. Your lordship, I furnished all the documents. I've furnished the sale deed copies, Form 26 AS.
Even if my learned friend says that before passing the show cause notice on 23rd January 2023, his last objection has not been considered. After the show cause notice, he has filed reply. Thereafter, assessment order has been passed. His last reply after the show cause notice, that has been taken care by the assessment of assessing officer. Even reply.
But one thing, Mr. Bhattacharya, you see, there are 3 issues.
Yes.
You please come to page 133.
133.
issue number 1. Please correct me if I'm factually wrong. Hence, no adverse inference has been drawn on this issue. However, it is noteworthy that the original assessee had not filed return of income under 139, only filed it afterwards, notice under 148. In view of this, penalty proceedings under 271(1)(c). So on the issue regarding the salary, income, etc., no adverse inference or no adverse inference is drawn, only on the belated filing of return. Then come to issue number 2. He has given a detailed explanation how he got the money, what is the gratuity he received after his retirement, etc., etc. Bank statement. Then come to page 134, first paragraph, last 4 lines. However, the assessee has shown income of so-and-so from other sources also includes 1,09,000 difference between market value and stamp duty only after receiving notice. Hence, penalty proceedings under 127, 271(1)(c). Then come to issue number 3. Third line. Hence, no adverse inference has been drawn on this issue as well. However, note 139 so-and-so has been filed, penalty proceedings separate. Actually, on the 3 issues, no adverse inference except for second issue. There is a marginal difference of the market value of 1,09,000. Your assessing officer is harassing. He's harassing. Wish that the assessing officer had to go to the Vidyasagar State General Hospital at Behala when he was working there for treatment under this doctor. He is harassing. This faceless officer is harassing. And there is no addition proposed. What is being proposed is penalty, and penalty cannot be levied in this case. Once he has not drawn adverse inference and he has accepted and processed the return under 113, though filed belatedly, he is stopped from going back. Entire proceedings has to be quashed.
Your lordship, Lord, taking the assessment order as merit, that is not the writ petition at all.
Maybe, but this is harassment. See, in fact, I was under the impression
that he has to argue in merit after filing 20% of this tax amount.
And that is different. But the thing is, you imagine someone 1 lakh difference, 100 crores difference. You are not able to touch. You are not able to take it to the valuation officer. They are afraid to touch the assessee. Even the faceless system is afraid to touch the assessee when they see the multiples and zeros behind the first figure. And here is one individual assessee, he is being beaten black and blue. Sir, please take down. This intra-court appeal by the writ petitioner is directed against the order dated 5th of April 2023 in WPA 6563 of 2023. The said writ petition was filed challenging an assessment order passed under section 147, read with section 144 capital B of the Income Tax Act 1961, dated 3rd February 2023, relating to the assessment year 2015-16. The learned appellant in the writ petition had raised several grounds touching on the factual matrix as well as legal issues, apart from stressing on the point that the assessment order has been passed in violation of the principles of natural justice. In as much as the reply which was uploaded by the appellant on 24/1/2023 in response to a notice issued under section 142 within bracket 1 of the Act dated 11th January 2023 has not been considered by the assessing officer while completing the assessment on 3rd February 2023, from which it is seen that in which the assessing officer has recorded as if no reply has been submitted by the assessee. Further, it is submitted that the assessing officer did not take note of the factual, take note of the reply / objection filed by the appellant dated 25th January 2023 to the show cause notice dated 23rd January 2023, in which all factual issues have been fully clarified. On these grounds, the appellant sought for setting aside the assessment order. The learned single bench by the impugned order held that the appellant should avail the alternate remedy of filing an appeal before the Commission of Income Tax Appeals and accordingly dismissed the writ petition. Aggrieved by the same, the appellant has preferred the present appeal. We have heard so on so since. When we heard, pardon?
Dr. Milord.
Yes. When we heard the matter on 11th August 2023, we issued a direction to the respondent department to clarify as to whether the e-response to the notice dated 11/1/2023 had been received by the department prior to the passing of the assessment order dated 3/2/2023. The learned senior standing counsel appearing for the respondents have the instructions and they placed the same before this court. After elaborately considering the manner in which the assessment proceedings had proceeded, we find that the appellant assessee has been unnecessarily harassed by the faceless assessment center by repeatedly issuing notices to the assessee, who is an individual, a retired medical practitioner. It is not in dispute that the assessee had cooperated with the assessment proceedings and responded to the notice issued under section 142 within bracket 1 of the Act dated 11th January 2023. But the only mistake committed by the appellant assessee, is to upload his reply on 24th of January 2023, though the reply is dated 19th January 2023, that is beyond the due date for submission, which was fixed by the assessing officer, as 16th January 2023. Even assuming so, there was a marginal delay in uploading the e-response to the show cause notice dated 11th January 2023, issued under section 142 within bracket 1 of the Act. Nothing precluded the assessing officer to take note of the said reply, since thereafter the assessing officer did not complete the assessment but thought fit to issue a second show cause notice proposing variation, and this notice is dated 23/1/2023. The due date for filing a reply was fixed as 28th of January 2023, and the appellant, well before the due date, has submitted his objection/reply on 25/1/2023 and uploaded the response on the very same date. Therefore, nothing prevented the assessing officer from going through the reply and perusing all the documents and particulars furnished by the appellant. Though, not though. On a perusal of the assessment order dated 3/2/2023, we find that the approach of the assessing officer to be absolutely perverse. The assessing officer has pointed out 3 issues. And from paragraph 3.4 of the assessment order, dated 3rd February 2023, we find that no adverse inference has been drawn on issue number 1. So far as issue number 2 is concerned, though the assessing officer points out that there is a marginal difference between the market value of the property purchased by him and the stamp duty value, no adverse inference has been drawn against the assessee on this said issue. Coming to the 3rd issue, we find once again the assessing officer has not drawn any adverse inference on the said issue. However, in a most perverse manner, on all the 3 issues, the assessing officer states that penalty proceedings under section 271 within bracket 1 within bracket small c of the Act is to be initiated separately for concealment of income. The said finding rendered by the assessing officer is not supported by any reasons. Full stop. In the absence of any adverse inference being drawn by the assessing officer on any one of the 3 issues, the question of coming to a conclusion that the assessee has concealed his income does not arise. Full stop. Further, further on issue number 2, as noted, the difference in the market value and stamp duty value of the property is very marginal, being less than being less than rupees 1,35,000. Probably the assessing officer, realizing that the marginal difference is of no significance, did not draw any adverse inference. Full stop. Furthermore, the assessing officer would contend that the return of income was filed by the assessee only after notice has been received under section 148 of the Act. To be noted that the assessing officer has taken on file the return which was presented by the assessee, and based on the return, the computation has been done. Therefore, the assessing officer at this stage of the matter cannot fault the appellant for having filed the return of income after having received the notice under section 148 of the Act. Therefore, the conduct of the assessee in filing the return after he received the notice under section 148 of the Act cannot give a cause of action for initiating penalty proceedings. Thus, the entire assessment order is absolutely perverse and unsustainable in the eye of law. In the result, the appeal is allowed, and consequently the writ petition is allowed. The impugned assessment order dated 3rd February 2023 is quashed, and consequently the proposal to initiate penalty proceedings under section 271 1C of the Act by issuance of the notice dated 3/2/2023 is quashed, and the assessing officer is directed to accept the return filed by the assessee in its entirety and proceed to complete the assessment within 3 weeks from the date of receipt of the server copy of the same.
My lord, may I request to one thing, my lord? That your lordship closed everything.
Yes, we have done complete justice. So
yes, only one thing, your lordship's order recorded that the steps taken by the assessing of harassing, they are doing their job. Your lordship kindly delete that line.
No, we want to impose cost, but it is faceless. Otherwise, you would have summoned this fellow. Summoned this fellow and sent him for some treatment to the very same doctor. This is harassment, sir. 1,33,000 is the difference, which includes his personal saving amount of 1,09,000. And it's all right. well and good. You say?
May I share my lord one experience? My lord, in our my lord discussion with the my lord, this officer, my lord, they have said us, my lord, they have treated my lord some in that way, my lord, in their my lord, when they are going my lord in any my lord, their discussion, any my lord, they have treated in that way, my lord, they have to give collect tax, my lord, some that way, my lord. Not that my lord, they are doing personally something to the assessee, my lord.
No. They have to know to
Blood is IRS officer.
separate. No, someone, you hear me. They have to know to separate the chaff from the grain. That's the duty of an assessing officer. He may be faceless, he may be with the face, no problem. So what is reasonable explanation? This man says, sir, this is my saving, this is my gratuity amount, this is what I got after retirement, this is from this bank account. He gives all the statement. This fellow doesn't draw any adverse influence. He falls back on a return which has been processed already. He should have failed to accept the return and he should have proceeded under 144 and completed the assessment on best of judgment basis. Once having accepted the return, processed it. Poor man. Let him be in peace.
Grateful, your lordship.
Yes, next.
Item number 4.
My lord, I am pleading not to be my lord honorable Mr. Larnet Senior Advocate Prince P.K. Das. Is my lord,
Where is Mr. Das?
Not coming, my lord, due to illness, my lord. Some
You argue.
not
What
to,
is the interim order, Mr. Siddiq, they wanted?
I do not know, my lord.
There were two orders.
I do not know.
One order for cancellation of registration, which was passed on 30th January 2018. And
Ah.
another, my lord, there was one report, provisional report, which is of 29th of this 21st of December 2022.
Where is that order, sir? Cancellation of registration.
Cancellation registration order is at page 60.
60.
These are the two mandamus they had sought in the writ petition.
My lord, kindly not to be, my lord.
Wait, sir. In not this year, then it will come only in 2024. Order of cancellation. This is reference to your reply dated and notice. Address of the principal place of business as mentioned in the trade license does not match with the address of the applicant. The partnership will. For own premises, please upload any document in support of the ownership of the premises later. No response to query raised. My goodness. But they did not upload the response immediately.
They do not, my lord. This is a case of getting the provisional registration prior to the GST Act coming into force, and after the GST Act came into force on 1st of July 2017, they did not take any steps to get this affirmed, this registration affirmed. And but still, with the provisional registration which was cancelled, they carried on business up to 2019. So there was a final report which is appearing at pages 56 to 59 of the stay application. So both this cancellation order and the final report, the business which they carried on with the cancelled registration, my lord, both those were assailed before the honorable single judge, and they took out a supplementary affidavit also. A show was issued, which is appearing at page 123 of this stay application. In DRC 01, the show cause notice was issued, my lord.
My lord, only not to be, my lord.
Thereafter, my lord.
All right. He is not ready, sir.
Stage.
Kindly not to be, my lord.
Not to. Yes, next.
Item number 5.
I am for the respondents.
Yes, sir. What is this, sir?
Lord, kindly, Lord, I have come against it in respect of the research.
Sir, use the mic.
Seizure operation.
Pardon?
Lord, I have come in this matter in relation to a search seizure operation carried out at Ranchi station of my stock in trade, the jewelry. Lord, my staff traveled from Calcutta to Ranchi and reached Ranchi station in the morning of 14th November 22. There, the Railway Protection Force people detained them, took to their office at the station and took possession of my jewelry stock and informed the income tax officers at Ranchi. The income tax investigation people came to the station, took my statements of my employees and seized the stock in trade. Lord, it was informed to them that they have carrying the valid documents to carry the goods from Calcutta to Ranchi. Those documents were given to them, but they seized it now, and they are in continued possession of those stock in trade in spite of repeated reproduction.
Sorry for interruption, sir. The learned judge has not dismissed a writ petition. He has directed affidavit to be filed. Now you want return of the seized ornaments.
Yes.
But should you not apply to the assessing officer for return?
No, we did inform my assessing officer at Calcutta. We did request the investigating officers at Calcutta and Ranchi. The Calcutta investigating officers were making daily inquiries right from the date when the goods were seized in November 22, and we produced all documents to show that they are stock in trade.
No, according to the department, all the documents, etc., have been handed over to the DCIT Central, Circle 13, who's your assessing officer. You file an application before him, and you also file, if you have already filed a return of income, whatever it is, he has issued you a notice under 142, etc. In the you ask him to decide that issue and release the ornaments and documents. At the interim stage, how in a writ petition we can impede this?
No, it is the one and the only petition it is, which is repeatedly being taken up without giving me the relief of the. My lord, this section says that the goods is stock in trade cannot be seized at all. Only
True, sir, but then that is a disputed question. You will have to establish it before the assessing officer that this was stock in trade. So where is your application before the AO for return of the goods, stating that it is goods, it is not a contraband or anything, it is stock in trade? Where is your request? Please return the goods.
My lord, so far as the establishing the question of stock in trade before the assessing officer, my lord, at the relevant time in November, my assessing officer was at Calcutta, but investigating officer at Calcutta was making inquiry, and I produced the documents of stock in trade and all, that these are my stock register, this is my manufacturing register, and these goods, how they have been carried under the GST law to the Ranchi, and established that it is stock in trade. There is no finding against me by the Ranchi investigation.
No, the DDIT which did the investigation, you have given your representation, but he has not returned any finding. On the contrary, what he did was, he gave all the documents and etc. to the Deputy Commissioner of Income Tax, Circle 11-1, Kolkata. You have rightly sought for release at page 137. Please see page 137, Annexure K. Page 137.
Because 127 is
137.
page.
Yes. He will consider this. He will pass an order. See, this midway, it cannot be done. You can't.
Respectfully,
don't short circuit the matter. You don't short circuit the matter. And after giving the representation on 27th of February, immediately writ petition was filed. WPA 7637. And what is the prayer in the writ petition?
127 in my representation at Calcutta.
Yes.
That are all stock in trade, and the decisions which I relied on the board circular, which says that the stock in trade cannot be seized. Only an inventory can.
No. We can't decide that. Where is your writ petition? Copy of your writ petition. Prayer in the writ petition.
Copy of the writ petition. May I?
Page.
Lord, may I furnish the copy of the writ petition?
It is not available in this set. Why have you not filed it? You are instructing counsel.
The prayers in the
Milord, the-
also for return of the gold.
Yes. Sir, for the present, what we can do, there's no useful purpose will be served keeping a writ petition pending. For the next 2 years, nothing will happen. So he will consider your representation at page number 137.
Yeah,
But-
your lordship, two things which I most respectfully pray for your lordship. One, they have appointed a assessing officer of my employee because the employee was carrying on the goods. So they have appointed an assessing officer of that instead of me. Now, so I have to justify before my assessing officer because in all the cases, it is the owner of the goods who is to justify it is stock in trade or not.
Now, which officer is in possession of the documents and this bullion or whatever jewelry?
The assessee, the petitioner, he was in possession, he was carrying as an agent.
No. As of now, it is in the custody of which officer is holding custody?
May I say this?
At Ranchi, respondent number 3. The officer at Ranchi is in charge of this. Respondent number 3. He is still in possession at Ranchi. He has not transferred the seized goods to the officer at Calcutta.
No, Ranchi is out. Respondent number 3.
Yes.
Ranchi is outside the jurisdiction of this court. You go to Jharkhand High Court.
No, kindly, Millard.
Sir, you have given a representation to Deputy Commissioner of Income Tax, Circle 11-1.
132 says that if a seizing officer has no jurisdiction and the assessing officer is a different one.
Decide that, sir. Sir, we cannot decide that. Or we will dismiss the appeal. The question of granting any interim order doesn't arise. Let your writ petition come after 3 years. No problem.
Millard, it already, Millard, under the section, these are to be transferred to the assessing officer. Now, my assessing officer is at Calcutta. The respondents have also appointed an assessing officer of the survey, my employee at Calcutta, who was carrying the goods. So, assessing officers are at Calcutta. Now, the law requires them to transfer the goods to the assessing officer and the documents and all. Now, only they have transferred the documents to Calcutta. The goods, the seized goods are still lying at Karachi. Now,
yes,
I have to pray
yes, sir. Sir, please hear the order. Please take down this intra-court appeal by the writ petitioner is directed against the order dated 14/6/2023 in WPA 7637 of 2023. We find from the interim the full stop. The appellant is aggrieved by the impugned order in as much as the learned single bench has not granted any interim relief, but directed affidavits to be filed. On going through after hearing the submissions of Mr. Muraka, learned senior advocate, as well as Mr. Aryak Dutt and Mr. Soman Bhattacharya, learned standing counsel for the respondent department, and perusing the relief sought for in the writ petition, we find that the relief is to return the seized goods and articles, which according to the appellant has been unauthorizedly and illegally retained by the third respondent, who is an officer of the income tax department situated in Ranchi, Jharkhand state. Considering the facts and circumstances, the learned single bench rightly held there is no scope for granting any interim order. Therefore, we find no grounds to interfere with the order passed by the learned single bench. Accordingly, appeal is dismissed. The department is directed to file their affidavit in opposition in terms of the directions issued by the learned single bench. Next.
Milord, one thing, may I make one your lordship always hears us, Milord, kindly one thing. He has directed affidavits to be filed and matter to be fixed in the list. That is the only direction he gave. Now, what I am respectfully praying is, that the two officers who are appointed at Calcutta, he is not a party at the moment. So that because he has been appointed as the assessing officer at Calcutta. Now, therefore, I made this application for addition of party. Now,
You do that in the writ petition.
one thing,
The appellant is granted, please take down, the appellant is granted leave to seek for inclusion of additional respondents in the writ petition. Next.
Milord, one thing.
Affidavit in opposition is ready.
One thing more, Milord, may I? Let the goods be sent from Ranchi to Calcutta. Because
You go to Jharkhand High Court, sir. You can appear online also. Next. Sorry, sir. Sir, we have heard you, sir. You have heard you, sir. Sorry, sir. Please,
And
next.
come before the Calcutta. Your Lordship may not dismiss it. Let the office come to the London trial court. See, he has already directed the
Pass
matter.
the order, sir. We have passed the order. Sorry. Next.
Item number 6.
Yes. No scope for passing interim order. Involved requires affidavit. Let affidavit be filed. Rightly so. Same order.
Lordship, I appear for the petition. Lordship.
Yes.
It was heard on the last occasion for some time, but again, due to paucity of time. Lordship, the issue is, Lordship, I am an exporter of service. I export services, Lordship. All the conditions for refund were satisfied. I received the payment from my supplier based out of foreign country, but during the conversion, Lordship, when the payment is sent from the USA customer to India, an intermediary is involved to transfer, to convert this foreign currency to INR. Lordship, in the adjudication order as well as in the appellate order, I had referred to various judgments of the erstwhile service tax regime wherein the perimetry provisions were there, wherein the courts have held that if it is convertible for an exchange and if it is converted and sent to India in INR, that is also within the meaning of convertible foreign exchange. Lordship, kindly come to page 171. Where is the provision, Lordship, of export of service? 171 in the state.
Yes.
Lordship, section 2, subsection 6, export of service.
Yes.
And clause 4, clause 1, 2, 3, 5, they are not disputing. Clause 4, the payment of such service has been received by the supplier of service in convertible foreign exchange. Lordship, the word is convertible foreign exchange. Now, Lordship, I'll show you the documents.
So remittance has been in Indian rupees.
Lordship.
Remittance has been in Indian rupee.
Yes. Lordship, convertible foreign exchange, converted and remitted in India. That was.
Mr. Kanodia, what is the interim order we can grant?
My
you are trying to argue the writ petition without an affidavit.
My humble prayer is that this has not been considered by the lower authorities. I am only seeking remand, Lordship, because my entire business is based on this refund. I am only an exporter of service, and both the lower authorities has not discussed this at all, Lordship. I'm just praying for remand of this proceeding so that they can discuss on this point of what is convertible.
Where is the order passed by the Joint Commissioner dated 31st March?
Lordship, that is at page 154. It starts at 154, Lordship. The relevant discussion is at 158. And type copy is at 158A. 158A is the type copy, Lordship, para 6. Para 6, para 7, now para 8 is the main point. Para 8, the Joint Commissioner notes down the provisions. Then, Lordship, para 8, last paragraph, after clause 5, he states, but here, I find that the importer had sent remittance through an agency located outside India who had remitted INR. So, Lordship, this is not correct because there are documents which to prove that he had remitted dollars and converted through Wise INC. Wise INC is like, Lordship, PayPal. Like PayPal is an agency converting the foreign exchange. Similarly, is Wise agency. Lordship,
produce those documents.
Lordship, those documents were there in the appeal paper book also, Lordship. I can show you, Lordship. That is at page number 59 onwards, Lordship. Lordship, 64. Page 64 onwards, there was a bunch of documents given to show this transfer was dollar.
All right. Now, against the order passed by the Joint Commissioner, why did you file a writ petition?
Lordship, there is no tribunal. And Lordship, my only business
tribunal is not there.
because the 2 years is imputed in this petition, Lordship, my refund is of 40 lakhs. And next year, 22-23, Lordship, I am unable to file my refund because of this. Lordship, they have not, the only humble submission, my Lordship, is that this convertible foreign exchange, based on the judicial precedent and the erstwhile regime, they have not decided at all, Lordship.
No,
Lordship,
but what he says is that those judgments will not apply.
Lordship, that is what, Lordship, page 159.
I find the referred promotions so and so, there are case-to-case basis.
Lordship, page
What Mr. Meity, that may not be right. The legal principle of the ratio decidendi has to be considered. He can't say that was delivered by that court, this was delivered because my standing counsel Meity did not appear. So therefore, I will not see that judgment.
Adjudicating authority, also during the adjudication proceeding, these case laws were given. He also they were considered. So, Lordship, if your Lordship can remand it to the adjudicating authority so that he takes into account, or the appellate authority as your Lordship deems fit. Because this is only a single point dispute, Lordship, and my entire business is stopped because of this, Lordship.
Yes, what do you say, Mr. Meity?
My lord, in this case, your lordship will kindly see, my lord, most probably your lordship is the foreign exchange management I want to rely. Foreign exchange management, my lord. Here the foreign exchange has been defined under section 2N. It says, my lord, deposit, credits and balance payable in foreign currency. Drafts, travelers checks, letters of credit or bills of exchange expressed or drawn in Indian currency but payable in foreign currency. Drafts, travelers checks, letters of credit or bills of exchange drawn by bank, institution or persons outside India but payable in Indian currency. Now your lordship will kindly see section 8 of the said regulation. Realization, my lord, I am reading, my lord. Realization and repatriation of foreign exchange, save as otherwise provided in this act, where any amount of foreign exchange is due or has accrued to any person resident in India, such person shall take all reasonable steps to realize and repatriate to India such foreign exchange. My lord, that is in the foreign exchange, nothing else.
No, foreign exchange, what he says is, whatever is the transaction made, the transfer was in a foreign currency. And it is through a medium or some organization, through banking channel, approved banking channel. It has been remitted in Indian rupees. That is the document he has placed. Can you deny?
My lord, that is required to be obtain a permission from the Reserve Bank of India. Where is that permission? He is not obtained the said permission that I am forwarding the Indian currency from outside India, my lord. That permission is required.
No.
No such permission.
No. He has not done it. He uses an intermediary. There is an intermediary like the Rupee Pay, PayPal. There is an intermediary. That intermediary might have taken permission from Reserve Bank of India.
That is might have taken. The word your lordship is using the word whether
yes,
he
might have taken.
This.
Otherwise, the money cannot come inside India.
My lord, your lordship will kindly see the definition of export service, Rule 26 of the IGST Act. IGST Act, Rule 26(4) provides the payment of such service has been received by the supplier of service in convertible foreign exchange or in Indian rupees wherever permitted by the Reserve Bank of India. So in this case, it has been permitted by the Reserve Bank of India. He has exported the goods, so he is required to obtain the permission from the Reserve Bank of India, not his agent. His agent is not required. He is required to obtain the permission from the Reserve Bank of India.
But that the officer has not considered that. His reasoning is not that.
Then your lordship can remand the matter to the adjudicating authority to the extent this portion, my lord.
That's what he wants.
And to consider
where is the adjudicating authority's order? Adjudicating authority's order.
Adjudicating order is, lordship, at
page 98.
Page 98. It's a table, lordship. The order is in the form of table. Page 98, lordship. Clause number G. Clause number H. Page 99. Clause number H.
98.
99, lordship. 99, clause H. Then table, lordship, the export of service is defined, and then, lordship, in the instant application, it is found that importer has sent remittance through an agency Wise US INC located outside India who has remitted INR who has remitted INR to the applicant. It means remittance was not received in foreign convertible exchange by the applicant, therefore violated this. While submitting RFD 9, the claimant has submitted judgments, all these judgments. Then he writes, all the above orders of different state authorities are related to pre-GST era. CBIC has not amended the legal definition of export in IGST. CBSE has neither issued any subsequent circular instruction in the light of which refund order in favor of claimant can be issued. Therefore, above mentioned refund application is rejected. Lordship, the exact perimeter area provisions existed in service tax rules. Perimeter area, not a full stop comma has changed.
All right. We'll send it back to which respondent is this man? Adjudicating.
Lordship, adjudicating authority is respondent number 1. Respondent 1. The Assistant Commissioner, BBD Bagh 1 Division.
This intra-court, please take down, sir. This intra-court appeal by the writ petitioner is directed against the order dated 22/6/2023 in WPA 129/14 of 2023. By the said order, the learned single bench had declined to grant any interim orders and directed the respondents to file their affidavit in opposition. Agreed by the same, the appellant has preferred this appeal. With the consent of the learned advocates on his side, and at their request, the writ petition along with this appeal, writ petition is taken up along with this appeal for being heard and disposed of by this common order. The appellant had challenged an order passed by the first respondent dated 14/6.
19/8/2022, page 98.
19/8/2022. Where do you get the date?
Lordship, date I am telling.
No.
Lordship, the date you will get, Lordship, it's at page number 103. Page 103. In the top right side. There's a RFD 6, the order.
19/8/2022, by which the application filed by the appellant for refund was rejected.
Lordship, there are two periods and 2 orders, but both orders are dated 19/8/22.
The first respondent by the said order, after referring to the definition of export of services within double inverted commas, as defined in section 2 within bracket 6 of the IGST Act, 2017, held that the appellant had filed the applications for refund. No, held that from the applications filed by the appellant for refund, it is found that the importer has sent remittance through an agency within bracket WISC, all capitals, US Incorporated, bracket close, located outside India, who has remitted INR to the appellant. The first respondent therefore held that the remittance was not received in foreign convertible exchange by the appellant, therefore violated condition Roman 4, small Roman 4 of section 2 within bracket 6 of the Act, and accordingly the applications were rejected. Violated of condition 4 of section 2 within bracket 6 of the IGST Act 2017. The first respondent has referred to 6 decisions which were relied on by the appellant and would state that those decisions are relating to pre-GST era. And CBIC has not amended the definition of export of services in IGST Act. Therefore, the refund applications were rejected. The appellant carried the matter on appeal before the appellate authority, namely the second respondent. And second respondent, who by order dated 31/3/2023 dismissed the appeal, confirming the order passed by the first respondent. Agreed by the said order, the appellant had filed the writ petition since no tribunal has been constituted under the provisions of the IGST Act. We find that, no, firstly, we need to point out that the manner in which the decisions which were referred to by the appellant were not taken note of by the first respondent is incorrect. If a parameteria statute existed in the service tax regime, then the authority is required to take note of the ratio decidendi laid down in the various decisions and then make an analysis of the same and consider the applicability of those decisions to the facts of the case of the appellant and then take it and then arrive at a conclusion. However, this appears to have not been done by the first respondent. The appellant's case is that if the amount is received by the Indian resident in Indian rupees through an exchange house situated in a country outside India, having its account with an authorized dealers, then such remittance shall be deemed to be receipt of foreign currency. The appellant's case is that the exchange house, namely WISE US Incorporated, WISE, WISE US Incorporated, through its VOSTRO account with HDFC Bank Limited, which is an authorized category 1 dealer under FEMA Act 1999, has converted the remittance received in US dollars to Indian rupees and transferred the same to the bank account of the appellant. And therefore, the appellant submits that the remittance qualifies the condition specified in Regulation 4 within bracket 2 of the Foreign Exchange Regulation, 2015, and the remittances shall be deemed to have been received in foreign currency. The appellant also places reliance on Regulation 3 of Foreign Exchange Management within bracket manner of receipt and payment bracket close Regulation 2016 issued by the Foreign Exchange Department of the Reserve Bank of India by notification dated 2/5/2016, which provides for manner of receipt in foreign exchange, stating that payment in rupees from the account of a bank situated in any country within bracket other than a member country of Asian Clearing Union or Nepal or Bhutan, is a manner of receipt of foreign exchange. The appellant has relied upon various decisions of the tribunal, wherein there is a reference to a decision of the Hon'ble Supreme Court in JP. What is the citation that JP Mora?
Lordship,
You come to page 181.
Lordship,
The Supreme Court judgment in the case of JB Bodha and Company.
Lordship, I am just referring to that. Lordship,
Where is the citation? It says Supra. Where is Supra? All right. You give the citation to the assistant registrar. Further, the appellant placed reliance on the decision of the Honorable Supreme Court in JB Bodha so and so, reported in so and so.
That page 183. Page 183, cases cited, Lordship, third case. JB Bodha and Company.
JB Bodha and Company Private Limited versus Central Board of Direct Taxes, 2002 TIOL 2578 SC-IT. The appellant also placed reliance on the decision of the Bangalore bench of the SESTAT in the case in a decision reported in 2022-56 GSTL 411 within bracket TRI-BANG bracket close, wherein it was held that the exporter cannot be denied the benefit of export services simply on the ground that the payment has been routed through a third party, which is also based outside the country. Several other decisions have also been relied on by the appellant, and it is submitted that there are and it is submitted that those decisions had to be considered. Those decisions have not been considered by either the first respondent or the second respondent. Further, the appellant also places reliance on various judgments under the service tax regime to support their contention that merely because payment is received in Indian rupees, it cannot be said the payment against export has not been received in convertible foreign exchange as provided in Export of Services Rules 2005. Since these issues have not been thoroughly adjudicated either by the adjudicating authority, namely the first respondent, or by the appellate authority, we deem it appropriate that the matter should be remanded back to the original authority, namely the first respondent, to consider the matter in a holistic view, to consider all issues in a holistic manner, and take note of the ratio decidendi, which can be culled out from the various decisions which had been relied on by the appellant, more particularly the decisions which were rendered when rendered during the service tax regime. For such reason, the appeal and the writ petitions are allowed, and the orders passed by the first and second respondent are set aside, and the matter stands remanded to the first respondent to afford an opportunity of personal hearing to the appellant and take note of the observations made in this judgment and order, and pass fresh orders on merits and in accordance with law as expeditiously as possible, preferably within a period of 3 months from the date on which the personal hearing is concluded. Next.
My lord, add only one line. Your lordship has not gone into the merits of the case.
Needless to state that this court has not gone into the merits of the case, and the facts have been set out in the preceding paragraphs, and the submissions of the appellant have been noted. It is full stop. It is for the first respondent to take note of the factual and legal position and arrived at a proper decision in accordance with the law.
My lord, may I switch over to original side or continue appellate side?
How many more matters are there? What is the time? We'll finish this now. 3 more matters. You call next item. Appellate side.
Item number 7.
May I be permitted to appear virtually, Your Lordship? I am not too well today, so that is why.
Same with me, Mrs. Ra. I am thanking Justice Bhattacharya for permitting me to appear online.
How are you doing, sir?
No, much better today. Yesterday after 3 p.m. I took some rest. Today also I will be on. What is it? The writ petition was dismissed, saying that you come with the unclean hands.
Yes, it was said that, my lord, may I read out the order first, page 9 of the memo of appeal?
No, we saw the order. It says
So, my lord,
prayer B. What is prayer B? You could have given a prayer B.
No, my lord, that prayer B is the main prayer, my lord. Kindly have a look at page 38, my lord, where prayer A and prayer B is there. My lord, may I submit the issue first, my lord? What is the issue?
No, first we'll see.
Okay, let us have a look at the prayer, my lord. Page 38.
Recredit 1.56 crores.
My lord, there was a blocking of the credit ledger, my lord. There was a balance of 8,21,044 on the date. My credit was blocked by 1,65,18,106. So, my lord, what happened is that when I went to file my return, my lord, when the blocking was done, on the date of blocking, it resulted into a negative balance. My lord, kindly have a look at page 45 from where the facts can be, my lord, I can explain the facts. Page 45, my lord, of the petition. Page 45, your lordship looks at opening balance is showing 821,044. 821,044 total last column, my lord.
45, sorry.
Page 45, sorry, page 45. Last column is showing 821,044.
821,044, yes.
Then again, serial number 1, there is a in the description blocked debit by 82,59,058, 82,59,058, total 1,65,18,116. Then there is a negative balance in central tax column, state tax column, and total tax column of 1,56,97,072.
That is negative balance.
Negative balance. So I'm not challenging that, my lord, because your lordship judgment is there that there can be a negative balance. So there is no problem with that. Then, my lord, on 21st of December, so this blocking was done on 12th of December. On 21st of December, I went to file my return for November 22. Serial number 2, my lord. November 22. So ITC accrued through inputs is credited to my account. So integrated tax 2 crore 7,73,221. Then central tax 3 crore 14,88,652. Then state tax 3 crore 14,88,652. So total 8 crore 37,5525.
Yes.
Now, my lord, kindly have a look at the balance available column.
6.8 crores.
6.8 crore. So automatically, my lord, it is recovered. What 156, the negative balance was there. It is adjusted against my balance. So it is recovered. My lord, whether any specific order is passed by the proper officer to recover it, or whether it is automatically done by the portal.
So this negative balance of 156,97072 has been adjusted from this 837,50525.
Correct, my lord. That is what I'm saying. That is what I'm saying.
Now, what is the balance available is 68,053,453.
Correct, my lord. So that is what that is why I said that, my lord, I principally challenge the blocking of the credit ledger, my lord, because it is absolutely perverse, arbitrary, and contrary to the provision of law, which I will demonstrate subsequently. But first, I need to cross over this judgment of the learned single judge, which says that I have come with unclean hands and I made a false prayer. So, my lord, the fact of the matter is that through this portal, my lord, the portal is not in the hand of the officer.
Then suppose we'll hear Mr. Siddiq on this. If suppose we are convinced, then we can restore the writ petition.
No, my lord, kindly hear me on, my lord, the what is the how the perversity of the blocking of the credit ledger is, and my lord.
No. Then we have to give opportunity to Mr. Siddiqui. He has to get instruction.
No, my lord, I'm not saying that, my lord. Just, my lord, having a look at the.
No, Mr. Sharaf, we will not send it back. We will hear him on merits. We will clarify this point. What you say, Mr. Siddiq, I think is not a false statement.
No. My learned friend is traversing on completely on a erroneous, my lord, perception. This, my lord, negative blocking, my lord, 1 crore 56 lakhs. When it is adjusted with 8 crore 37 lakhs, it comes to 6 crore 80 lakhs. And your lordship's judgment is already there. My lord, he says that we have, and we cannot, I can put it on affidavit. My lord, we cannot under rule 86A, because this is a lien. We cannot take this amount.
Correct, sir. That is correct. But he has not come with unclean hands.
That, my lord, the honorable single judge, in view of your lordship's judgment, has said that you cannot say that they have.
That judgment was never discussed.
What we'll do is we will clarify that. and we will direct you to file an affidavit within 2 weeks.
No, my lord,
We will,
Can do that.
my lord, kindly,
Here,
kindly,
we, my lord, the honorable single judge, and in, because of the.
my lord,
or we will hear it. We will hear the appeal itself.
kindly allow me, my lord, my business will be finished, my lord. My lord, the manner in which the blocking and the setting down of business is going
No,
on, my
no.
lord.
We have to hear him on merits. No, let us give him an opportunity at least to get instructions in the matter. We
Yes,
post the appeal after 2 weeks.
yes, my lord, no problem.
This intra-court appeal, please take down. We have heard so on. So this intra-court appeal is challenging an order dated 22/6/2023, by which the writ petition filed by the appellant was dismissed on the ground that the appellant has not come to the court with clean hands. As could be seen from the electronic credit ledger, there was a negative balance of rupees 156,97072. Subsequently, for the tax period November 2022, ITC had accrued through inputs, and there was an available credit balance of rupees 837,50525, and the department has adjusted the negative balance of 156,97072 from the said amount, and the balance is reflected, credit available is reflected as rupees 680,53453. Therefore, we find that the appellant was justified in contending that the sum of rupees 156,97072 has been recovered, and therefore a prayer for refund has been sought for. Thus, we find that the appellant had not approached the writ court with any unclean hands, and hence the appellant is entitled to be heard on merits. Instead of remanding the matter back to the writ court, we would direct Mr. T.M. Siddiqui, learned as senior government counsel appearing for the respondents, to get written instructions on the contentions raised by the appellant in the writ petition, and make submissions so that the appeal can be heard and disposed of on merits. List on so and so date.
After 2 weeks, Your Lordship?
Yes, any day to Sadiq wants.
Yes, ma'am.
Lordship, just record my submission, my lord, that the amount has not been recovered by us.
No, adjustment. Unclean hands. We'll remove that stigma and keep it open. Next.
Grateful.
Item number 8.
Next.
What is this, sir?
Lordship, this is a case wherein audit under section 65 of the Act.
Oh, two authorities are parallelly proceeding.
Lordship, that is the learned single judge, after having reliance on the judgment passed by a Lordship in RP Buildcom, has admitted the petition but asked me to participate. Lordship, I'll just take 2 minutes to tell you what is the
participate before two authorities or one authority?
One authority already completed. So the another authority which is now starting the investigation, there are 3 authorities, Lordship. Audit under 65 completed. Demands were made. I made the payment. Then DGGI issued me a notice on 24th of May 2022 after the audit was done. I participated in that. I submitted documents. That is pending. Now, Lordship, under section 61, my reign superintendent issues me a notice for scrutiny of return. Scrutiny of return saying that 1718 to 1920, which is already audited. Now I will scrutinize your return. Then, Lordship, what did the audit did? What was that audit memo for the same period? Kindly come to, Lordship, page 113 of the stay petition, which defines scrutiny of return, the section 61. Page 113, Lordship.
Now, you said first audit is over.
Audit is over, Lordship. Audit memo dated 25/3/22. I made all the payments.
Then, which is the next authority?
Is the DGGI, Directorate General of Goods and Service Tax Intelligence, DGGI. DGGI.
Then what did they do?
They issued a summons, called me for certain documents. I submitted all the documents. Because it was Jamshedpur, I told them I am not able to come there, but all the documents are submitted. And it is still
matter pending.
Pending.
Then which is the third authority now?
Third is, Lordship, my range superintendent,
Who?
that range superintendent, superintendent of
Range
CGH,
superintendent.
he has issued me a notice under section 61 of the Act under ASMT 10 for the same period, 1718 to 1920.
No, let the DGGI complete it.
Lordship, DGGI, yes, Lordship, even the points raised in by the superintendent, that is pending before DGGI. I will show you.
No.
Lordship.
Madam Rashri, you are appearing.
I am, my lord.
Now, we let the range superintendent wait because DGGI is a centralized agency.
My lord.
He is only a local man. So suppose these people, the DGGI can call for the entire range file to them and examine. And if they find something wrong with the range superintendent also, they can question him.
My lord.
Lordship, may I submit one point? Lordship, kindly come to page 113 once.
Yes. That's what we are saying something in your favor.
Lordship, I just want to draw this conclusion that this scrutiny of return exercise is entirely bad. DGGI is continuing. I don't have any problem. But this scrutiny of return is bad, Lordship. I want to just draw that conclusion because it cannot happen like that. Lordship, page 113. Scrutiny of return, Lordship.
Read.
Lordship.
Read. Please read.
Lordship, the proper officer may scrutinize the return and related particulars furnished by the registered person to verify the correctness of the return and inform him of the discrepancies noticed in such manner as may prescribe. If the explanation is found acceptable, the registered person shall be informed and no further action shall be taken. Now, Lordship, 61.3 is where I want is very important. In case no satisfactory explanation is furnished within a period of 30 days of being informed by the proper officer, or such period as may be permitted by him, or where the registered person, after accepting the discrepancy, fails to make the corrective measures in his return for the month in which the discrepancy is accepted, the proper officer may initiate appropriate action, including those under 65. I stop here. Lordship, my 65 is already done for this period.
What is the order date of order?
Page 115.
Page
115.
115. That is 25th of March.
Lordship, the date. Lordship, 65, the definition of audit, Lordship. It encompasses. Lordship.
You say that including those under section 65. We heard you saying that 65 is already been done.
Already done.
What is the date of that 65 order?
Lordship, 25/3/2022, page 66.
That is what we want.
Now, Lordship, I will like to read the definition of audit, Lordship. It is defined in the law. Conspicuously, they have defined what is audit. Because in the erstwhile region, the audit was never defined. Lordship, the audit definition is at page 121.
Para approved and settled. Very good.
Lordship.
Audit para has been approved and settled.
Lordship. Page 121, Lordship, definition of audit.
Yes.
213, I am reading, Lordship. Audit, examination of records, returns, and other documents maintained or furnished by the registered person under this act or rules, or under any other law for the time being in force to verify the correctness of turnover, declared, taxes paid, refund claim, ITC availed, and to assess this compliance with the provisions of the act and rules made. Lordship, it includes the examination of returns. So 61, scrutiny of return cannot happen after 65 audit. 61 says if there's a discrepancy, if the SSC is not making the payment, it can be referred to audit or a show cause can be issued. Now, Lordship, in my case, 65 already done, which is a very deep scope. And I will show through documents that all the documents which they are asking in 61 was already submitted in 65. I don't have any worries with DGGI, Lordship. DGGI is continuing. Let them continue. But the scrutiny which they have done for the same period for which an audit is completed is not within the ambit of the law, Lordship.
But in page 106 is the notice issued under section 61.
Lordship, 61, Lordship, page 113.
Notice is at page 106. Am I right?
Notice. Lordship, 106, Lordship, yes.
Page 106 is the notice now issued. If we compare, Rashri, please compare this with 106 and 66. Just for the period, financial year 17-18, July 17 to March 18, and 2018-19, page 66. Turn over to page 106. First period, paragraph 1, GSTR 3B returns, period 2017-18, July to March, same period. Para number 2, GSTR 3B 2A, period 2017-18, same period. And in this, conveniently, he does not refer to this audit report. See, audit para has been raised. He has given documents. Para has been approved and settled. Therefore, if first of all, whether this range superintendent can sit in judgment over an audit para which has already been raised by the, because an audit para, see, audit department sort of you know better that it is a sort of an independent unit. We also get, the High Court also gets an audit being done, internal audit, external auditors. Once the audit department, we may have officers in the range of cadre of superintendent, but he is an independent body within the system. Once he raises a query and the para is based on the para, if it is not satisfactory, they will refer it to the range superintendent.
Which is what the case has been in this, which is what the case is, my lord.
If may I just say one thing, if the audit is not settled, if I don't pay, they issue a show cause under 73 or 74, which goes into adjudication. It doesn't goes back to range. It communicates into a show cause notice under 73, 74.
By the audit themselves.
And adjudication is done by my division, not by the audit, by the divisional officer. Lordship, kindly come to page 54 once. This was the list of documents submitted during audit. Page 54.
Not required, sir, not required.
And page, on comparison with page 109, same set of documents they are asking. Exactly word to word same. How can 61 be done, Lordship, after 65 is completed? DGGI being an investigation unit, Lordship, I don't have worries. I am participating. I am not challenging DGGI's action.
Page 56 is it? Documents.
Lordship, page 53 is the audit notice, initiation of the audit notice. 54 is the list of documents they sought from me.
And this has to be compared with 109.
The 109, Lordship, the last page of ASMT 10, scrutiny notice. Lordship, last paragraph. In addition, you are required to submit the copies of balance sheet, PL, 26 years, ITR for the same period. Why should I submit it to him, this Lordship, my Lordships? It already submitted with the department and audit has been completed, which is very wide in nature. An audit communicates into a show cause notice under 73, 74. A 61 scrutiny can lead to an audit or a 73, 74. But both cannot come and tell me you give all the documents to me, Lordship. Your Lordship has held in ideal unique liators also. That Lordship, that judgment I have also placed in RP Buildcom as well as in ideal unique real estate, Lordship. The RP Buildcom judgment is, Lordship, at page 132. And the ideal unique realtor judgment is at page 135.
Yes, madam. What you like to say, Rashid?
My lord, my instructions are that in the instant case, there was a scrutiny that was required, and therefore there was documents that were sent to the range superintendent from the Director General of Analytics and Risk Management. And this was done on the 2nd of November 2022. And therefore the range superintendent, on receipt of this notice, is duty bound to ask for the document.
But unfortunately, in page 106, that is not forthcoming.
No, my lord, which is why these are the instructions that I received when we were asked to file our affidavit in opposition before the trial judge, my lord, which hasn't been done.
All right, then you file your affidavit. Till it is decided, this page 106 will remain stayed.
My lord.
This infra-court appeal by the writ petitioner is directed against the order dated so and so. In the order dated 37/2023 and WPA 10506 of 2023, by which the learned single bench was not inclined to grant any interim order. Agreed by the same, the present appeal has been filed. We have heard Mr. Ankit Kanodia, assisted by Megha Agarwal, learned advocate for the appellant, and Srimati Rajshri Venkat Kundalia, assisted by Ms. Ekta Sinha, learned standing counsel, appearing for the respondent. The question in the instant case would be as to whether the respondent authority can proceed further pursuant to the show cause notice dated the 17/4/2023, purported to have been issued under section 61 of the CGST Act 2017. The appellant's case is that for the very same period, the audit department had issued a show cause notice dated 5th April 2021 and called for several documents which were submitted by the appellant, and after being satisfied with the documents placed, the audit department has closed the case as approved and settled by proceedings dated 25/3/2022. It is further submitted that for the very same period, the DGGI has already issued summons and the appellant has submitted documents and the matter is pending before the DGGI. It is submitted that section 61 of the CGST Act deals with scrutiny of returns, and in terms of subsection 3 of section 61, in case no satisfactory explanation is being furnished by the assessee, or the assessee fails to take corrective measures in his return, the proper officer may initiate appropriate action, including those under section 65 of the Act. This having been done, the audit department having approved and settled the matter by order dated 25/3/2022, the range superintendent, the superintendent, CGST and Central Excise Range 1 Durgapur 1 Division will have no jurisdiction to issue the notice dated 17/4/2023, which is impugned in the writ petition. Further, the appellant's case is that they have never questioned the jurisdiction of the DGGI to call for documents, and they have submitted to their jurisdiction and supplied all the documents called for, and the matter is pending. Furthermore, it is submitted that in the show cause notice dated 17/4/2023, issued by the superintendent, Range 1, the documents which have been called for are identical and the same set of documents which were called for by the audit department, which were furnished, considered, and the audit para has been approved and settled. And therefore, it is the case of the appellant that the notice dated 17/4/2023 is without jurisdiction. Srimati Kundalia, standing counsel appearing for the respondent, would submit that directions have been received from the analytical wing of the department, and this has necessitated the superintendent to issue the notice dated 17/4/2023. In any event, the legal issue which is required to be considered is whether a fresh notice could be issued by the range officer when the scrutiny of return had been done by the audit department, which has culminated in an order under section 65 of the Act.
If the audit had done, not scrutiny of return.
Scrutiny, my
Audit, sorry. Audit had done audit has been conducted, which has resulted in an order under section 65 of the Act. This being a jurisdictional issue, this court is inclined to pass the following order, which will be enforced till the writ petition is heard and disposed of. In the result, the appeal is allowed. And for the reasons stated above, the notice issued by the superintendent, CGST and Central Excise Range 1, Durgapur Roman 1 Division, Durgapur, dated 17/4/2023 shall remain stayed till the disposal of the writ petition, being WPA number 10506 of 2023. The respondent is directed to file the affidavit in opposition in the writ petition, after which the writ petition will be heard and disposed of on merits in accordance with. Yes.
My lord, if I may add, my lord, I would like to then refer to a judgment, MS Suresh Kumar PP versus DGGI, my lord, which says that audit and investigation can proceed parallelly, and there is a bar on that, my lord.
That is no issues. Already Supreme Court has held. But here he says the audit para has resulted in a 65(6) subsection 6, no? 65(6) order, subsection 6, if I am right. It has resulted in such an order. So therefore, the range superintendent or that superintendent should trace his power to some other provision which will empower him to reopen an issue which had been settled.
My lord.
Yes.
Lordship, just one correction, Lordship. In the starting, you had mentioned show cause notice everywhere, but this is only notice, Lordship.
Only notice.
It is not show cause notice.
Oh, sorry. Please correct it.
It's only notice under 61.
Sir, one line you please add. The learned senior standing counsel for the respondent department places reliance on the decision so and so and so and so. Please give the citation, madam, in writing to the officer.
My lord.
In so and so, so and so, and would submit that investigation can parallelly proceed. Full stop. The applicability of the decision will be considered when the writ petition is taken up for hearing. Next.
Item number 9.
Mine. Thank you, brother.
Yes.
My lord, this is my application, my lord. I have come against the order of the learned single judge, which is.
You are not to be seen for a long time, madam. What happened?
My lord, I am suffering from knee problem, my lord, and probably I have to go for a knee replacement. Probably. My lord, the learned single judge, my lord, dismissed my writ petition on the ground that there has been a delay of 1 year, 1 month, and there is an alternative remedy. My lord, the reason for the delay has been explained in the writ petition because, my lord, the petitioner, my lord, on 12th of October 2022, fell down and fractured his patella, and for which he was advised bed rest. So, my lord, he could not come on time before the writ court.
But the assessee is a company.
My lord, no. The assessee is a
proprietorship.
My lord, he is a small businessman who exports leather goods. Now, my lord, what happened, my lord? If your lordship, I take you to the orders, it is full of irregularities and anomalies. My lord, first, my lord, kindly come to page 47, where proceedings were initiated against the petitioner by issuing DRC 01A. My lord, that is at page 47. If you're, I will draw your lordship's attention, my lord. It says that what are the brief facts of the case? Purchased from non-existing and non-functioning business firms or persons. And then, my lord, it says, please refer to the above proceeding in this regard, the amounts of tax, interest, penalty payable under section 73(5). Now, my lord, section 73 deals when somebody erroneously claims, my lord, ITC, which is not due to him, or pays less tax. And my lord, section 74 deals where there is fraud and willful misrepresentation. And my lord, the liability under section 73, my lord, so far as penalty is concerned, is less than under section 74. Now, my lord, thereafter, he's a small businessman, my lord. He depends on his accountant. He told his accountant to take steps, and probably he did not file a reply. Then, my lord, kindly come to page 49, my lord, which is a show cause notice. My lord, the show cause notice is issued under section 74. My lord, section 74, as I stated, my lord, deals with fraud, misrepresentation, and which is a serious allegation, my lord. Now, my lord, may I place section 74 before your lordship?
Not required. Please proceed. Complete the narration of facts.
Then what happened, my lord? Along with this show cause notice, my lord, an annexure was given, my lord, to DRC1, which is at page 54. My lord, the show cause notice itself is bland, but the annexure, my lord, is, yes, facts, so it's been stated. My lord, it states, my lord, that I'm reading page 54.
Non-existent RTP.
You have claimed ITC of such and such from one Balaji Sales Corporation, who is found to be non-existent and non-functioning at his or declared place of business and subsequently cancelled with effect from the date of registration. My lord, details provided, his name and the amount. And then, my lord, he says, in this respect, my lord, before the table, in this respect, the amount of tax, interest, penalty payable by you under section 73(5) oblique section 74(5). So, my lord, he's not even decided that what is my offense under section 73 or section 74. My lord, and he has given me no documents regarding the non-existent and non-functioning of the person from whom I have.
Even for this, no reply.
My lord?
No reply was given by the SSC.
My lord, he could not give a reply. My lord, then the order was passed. My lord, kindly come to page 55. My lord, it says an order under section 74. So, my lord, it from in the annexure to the DRC1, it says it could be section 73(5) or section 74. Then it comes to say order under section 74. Now, my lord, this is again a small, nothing there except what was stated, but he gave a full text of the order, which is at page 59, my lord.
Yes.
Now, my lord, here he says, which was never taken earlier, the first paragraph, in continuance of show cause notice issued under section 74 or as mentioned above is hereby issued in form GST DRC 7 for claiming ineligible input tax credit during year such and such by means of fraud and willful statement of Messrs. Mercury Leathers, which is the trade name of the petitioner. My
but
lord,
there was no allegation of fraud.
No allegation of fraud and willful misstatement in the show cause notice.
All right. This order was passed on what date?
Yes, my lord. It was passed on 8th April 2022. And my lord, on 12th August 2022, the petitioner fell down and fractured his patella.
12th August. He had 4 months' time.
Yes, my lord. He had 4 months' time. It is, I state that, but he could not, my lord, file an appeal. So, my lord, and then
okay.
He could have, my lord.
But
he
could have still with the continuation of delay. He could have.
My lord, the period for filing an appeal is the time for period for filing an appeal, my lord, has expired. So, my lord, he had to approach the writ court to go into the merits. So, and my lord, here also he said 4 suppliers. In the previous show cause notice, there was 1 supplier. Now he says it is found during the course of investigation that 4 suppliers have been cancelled by the respective jurisdictional officer with effect from the date of their original registration. And whose registration has been obtained by means of fraud, willful misstatement, and suppression of facts. My lord, I have no control over how my suppliers have obtained their registration. My lord, if their registration has been, if it is the allegation that they have obtained registration by fraud, willful misstatement, it is the authorities to see who have issued them registration. So, my lord, and then, my lord, they give me a number of invoices at the bottom, which was also not given to me in the show cause notice. And my lord, on going through it, I find, my lord, on the first 2 invoice, that is 2/12/2017 and 8/12/2017 are the only 2 transactions which I had done with Bishwajit Mondal, the supplier. And my lord, the other 2 transactions.
Tax liability is only 76,000.
Only 76,000, and my lord, they have recovered this by debiting my input tax credit ledger. And not only that, my lord, they have also attached my bank account. So I am, my lord, to.
What do you say, Mr. Siddiq? Some individual fellow, 76,881 already recovered. We will grant him 30 days time to file an appeal.
Yes,
no pre-deposit.
Commissioner had ample opportunity to file reply to all these show cause
All
notice.
right, sir. Some individual fellow.
And
This
my
intra-court appeal by the writ petitioner is directed against the order dated 15/6/2020 in WPO 12065 of 2023, by which the writ petition was dismissed on the ground of delay and laches. The appellant delay and laches will stop. Agreed by the same, the appellant is before us by way of this appeal. We have heard Ms. Rita Mukherjee and advocate appearing for the appellant, and Mr. T.M. Siddiqui, and a senior government counsel appearing for the respondent. The appellant was aggrieved by an order computing the tax payable, order dated 8/4/2022, directing the appellant to pay a sum of rupees 38,440.78 towards central tax and rupees 38,440.78 towards state tax. On the ground that the appellant was not eligible to claim input tax credit. Several grounds have been raised before us, contending as to how the entire proceedings are vitiated on account of various procedural and statutory irregularities. Further, it is submitted that there was no allegation of any fraud or willful misstatement on the part of the appellant. However, in the order dated 8/4/2022, the Assistant Commissioner of State Tax Beligata charge for the first time has made such an allegation. It is the appellant agrees that as against the order passed by the Assistant Commissioner, an appellate remedy is available. However, the assessee could not file the appeal on account of a fracture sustained by the appellant, and he was hospitalized and immobilized, as a result of which he could not meet his accountant to take steps to challenge the order dated 8/4/2022. In the meantime, the entire amount of rupees 76,881.56 paise has been recovered from the credit ledger of the cash ledger or credit ledger?
credit ledger.
From the credit ledger of the appellant, and there is also an attachment of the appellant's bank account. Considering the peculiar facts and circumstances of the case, and taking note of the and also taking note of the fact that the entire tax has been recovered by the revenue and the interest of revenue has been secured, we find this case to be a unique case where where a remedy can be granted to the appellant by affording an opportunity to the appellant to file a statutory appeal before the appellate authority. We make it clear that this order has been passed taking into note of the peculiar facts and circumstances and not to be treated as a precedent. In the result, the appeal as well as the writ petitions are allowed. The appeal is allowed and the order passed in the writ petition is set aside, and the appeal and the writ petition stands disposed of by directing the appellant to prefer a statutory appeal before the appellate authority within a period of 30 days from the date of receipt of the server copy of this order. If such appeal is filed, the appellate authority shall entertain the appeal without insisting upon any predeposit, since the entire tax has already been recovered. In the light of the above, the respondent authority is directed to lift the attachment of the appellant's bank account within 3 days from the date of receipt of the server copy of this document. Next.
Your Lordship, may kindly, my lord, record that your Lordship has not gone into the appellate authority.
Yes. Needless to state that the merits of the case have not been gone into, and it is for the appellate authority to take note of the submissions of the appellant and take a decision on merits and in accordance with law.
And my lord, the attachment will be withdrawn, my lord. That bank
within 3 days. Next.
I'm
number
grateful,
10.
My appeal.
Yes, sir.
May I file my affidavit of service? My lord, in this matter, my lord, my writ petition was dismissed by the learned judge on the ground of delay. If your lordship has the impugned order at page 25, it has been recorded that two orders of the first authority and the appellate authority were challenged by way of the writ petition after a lapse of 6 years. And that is why, in view of the inordinate delay, the writ petition was dismissed on the first day. But the facts of the case is, it is a fact that the first authority and the appellate authority had passed an order 6 years back. But what had happened in the meantime was that those orders were passed in violation of principles of natural justice, because one of the documents which I was directed to produce were in the hands of the authorities itself. And I had intimated the authorities time and again by various letters, which have not been disputed by the respondent, that I do not have the document. I had not retained any copies of the documents which were seized while an investigation was being conducted by the respondent, and that is the reason why I cannot furnish the documents. And I requested the authority to hand me back with the photocopies of the documents so that I can rely on them. On these facts, none of my letters were responded to, and the orders itself, the first authority's order and the appellate authority's order also records that while the seizing procedure, while the investigation was going on, the documents were seized, but it has neither been recorded nor has been considered as to why the documents were not.
But you could have preferred an appeal to the tribunal.
But I did not. The respondent did. The first authority passed an order. The authority itself preferred an appeal before the appellate authority, and in the appeal, the penalty, the amount of penalty was revised. It was increased.
Now, against that portion, you could have preferred an appeal to the SISTAT.
I could have, but even before the appellate authority, I had written to the appellate authority that I do not have the documents and I want to rely on them, but since no photocopy was retained by me, I cannot furnish anything. The appellate authority writes to me that I am to approach the concerned authority which has seized those documents. But that letter is also on record.
No, why did you not challenge this order dated 2nd of November 2018? Much earlier. What is the reason? Give explanation.
After this order was passed, various demands were made by the respondents for recovery, and thereafter, on 17th February 2023, the respondent number 6 intimated that recovery proceedings have been initiated against me. It is true that I did not challenge. I cannot better my facts. It is true I did not challenge the appellate authority's order of 2nd November 2018. But
all right, assuming, but in 2023 you filed the writ petition. Instead of that, could you not have gone to the tribunal?
By that time, the time period for preferring the appeal had expired. If your lordship, I am still willing to prefer an appeal from this appellate authority's order. But in the impugned order, if your lordship will see, only the dates of the order have been recorded. But my cause of action, it's a lordship knows it's a bundle of facts, dates of the order as well as recovery letter.
You need not wait till the recovery notice is issued to challenge the order. Recovery notice under 87 and 79 is a consequence to the adjudication order. What is that? Mr. Mehdi, it is only with regard to penalty or including tax?
Including tax. Evasion of tax of 33 lakh and penalty, modified penalty of 38 lakh.
The assessee should have filed an appeal against that portion of the order of the original authority demanding tax. We find both were on appeal before the commissioner.
No, both of the orders were not appealed against.
We will ask what is the remedy available to him, Mr. Mehdi?
My lord, your lordship can direct them to approach the tribunal. In the meantime, they will deposit the amount to the department, and if they win, they will entitled to get back the amount along with interest.
No, the problem is he has not filed an appeal against the order of the original authority demanding tax.
Yes.
You filed an appeal against reduction of penalty.
Yes.
Your appeal was allowed. Now, whether
my appeal is to the tune of penalty, not on the entire order.
But the appellant has not filed the appeal against the original authority's order, adjudication order.
That is their headache. They have not preferred any appeal. That means they have admitted.
It's a fact.
That means they have admitted their liability.
No, my lord, our principal ground is, my lord, we could not rely on the only contention of the respondent was that no documents were available by which I could prove that service tax was in fact paid or was payable. My lord, I had my documents which.
How much is the tax liability?
My lord, the tax liability is 33 lakhs, 33,50,003.
Along with interest and penalty.
Along with interest and penalty. Penalty was 38 lakh, my lord, modified.
No. Even if you can think over it, probably we can have it next week also. Even if we grant liberty, make some reasons, etc., and allow the SISTAT to entertain your appeal without rejection, it will be only with regard to the penalty component. But your substantial amount of 33 lakhs is a tax. Whether you can file a revision or what, you work out on that, you come back next week.
I'll do so. So my lord, next week I'll do so.
All right. At the request of so list next week in the same position. Don't push it down. Court officer.
Lordship.
Next.
Item number 11.
What is 11, sir?
I'm appearing on behalf of the appellant. Now, my lord, in this case, I am rendering services to Kolkata Municipal Corporation, various services by supplying them the personnel from my office. And my lord, now also, I am also rendering services to other body corporates like the Steel Authority of India, then ESI, Employee State Insurance, then to other body corporates like SAIL.
Sir, can subject to your convenience, can we take it up next week? Your item 10, 11, and 12.
Because I have to cite some decisions, I cannot do it here.
So item 10, 11, and 12, and 13 also.
Let it maintain its position, my lord, because that is very important, my lord. It should be taken up on the next day.
Yes. 11, 12, and 13.
In this case, your lordship, I'm sorry that it's already 1:20, but only 2 minutes. Now, my lord, what had happened, I came before your lordship just before a year, on 11th of July 2022. Your lordship was pleased to direct me, now, my lord, to direct the authorities to serve me a show cause notice along with the KMC, because KMC was making payment of the service tax. But subsequently, they stopped saying that from 1st of January 2014, they said that we are not liable to pay service tax because we are discharging constitutional duties. So we are not. Now, my lord, there is an exemption notification by the central government, which says that for certain services, these are exempted. And my lord, so far as security service or manpower service is concerned, to body corporates, they are liable to pay the service tax because this is RCM. That is reverse charge mechanism. Now, my lord, it's the service recipient who has to pay. Now, what has happened? After your lordship's order, show cause notice was given to us and also given to the case.
If he argued, my lord, on merit.
I asked the authority in my reply to the show cause notice. I said, kindly give me a copy of the reply given by KMC. Now, my lord, I wrote 3 letters. The first letter was on 5th of September 22, when I give the reply, then 6th of September 22, and then on the 14th of November, just 4 days before my personal hearing, I said, kindly give me copies of their reply to the show cause notice. Because they made allegations against me saying that I am liable to pay, but we are not liable to pay. Now, my lord, he did not give. Then we went for the hearing. After the hearing was over, we came to know that the hearing of KMC was taken in the morning, which behind our back. And my lord, after the hearing of both the parties was concluded, they gave written submissions, which were also not supplied to us, and we are not of the know of it. Then, my lord, 5th of December, I wrote on the 5th of December, my lord, I wrote a protest letter saying that I will not get any justice from you. Because you see, I have come to know that you have given them hearings separately. You have taken my hearing subsequently. Now, my lord, written statement has been given. You have proceeded with a closed mind. Now, my lord, what has happened in his order? He has passed my lord, an order wherein he says these documents were not there. Now, my lord, all these documents were relied upon documents. The documents are
Right,
there.
sir, the matter will retain its position. We'll list it next week.
I'm
Whatever
extremely.
is there. Huh? Yes, sir. Yours item 11, 12, 13.
Yes. Item 11.
11, 12, 13, not today.
13. I'm appearing only in 11. My juniors are appearing in the other two.
Yes,
They
sir.
are-
11, 12, 13, not today.
I'm deeply obliged.
Original side matters we can shift. At least applications alone.
Lordship, we take to item number 45, my lord.
No,
Let
let it remain in the list, sir.
my lord.
Anjan, original side, you please call.
Original side list item number 1 and 2.
Who appears,
I'm for the Union of India, my lord.
Respondent, you've been served. There is only 40 days delay.
My lord, your lordship can condone the delay and take up the matter next week.
All right. Item number 1 and 2, separate orders. We have heard so and so. We are satisfied with the reasons assigned in the affidavit filed in support of the petition, and the delay in filing the appeal is condoned. Application allowed. Then item 3.
3 and 4.
3 and 4, my lord, that is a delay of 26 days. But the main issue is that the notice under 148, if it is
Madam,
26
Mr. Rai
days
is opposing. He is opposing your delay. You are always opposing his delay. Today he is opposing your delay.
Pilot, there was summer vacation, so I required certified.
No, he says your affidavit is without any particulars.
And
That is always your argument. Now he is making same argument. All right. Item number 3 and 4. We have heard Ms. Swapna Das, Siddharth Das, Mr. Om Narayan Rai. Satisfied, same order, delay condoned. Next.
No, my lord, lordship, kindly hear on merit, its matter
Merit
is.
it will come. It will come. Next week it will come.
I don't know, 5 and 6.
Lord, I am appearing, my lord. There's a delay of 277 days, my lord, in filing.
Respondent served.
I appearing for the respondent, my lord. Lord, in this case, I am opposing this application for continuation of delay. Now, why I say?
You take an order on merit, sir. It is less than 300 days now.
Even this appeal has become infructuous, my lord. My lord,
Oh,
after
that
the
is-
passing of the impugned order, the department has issued a notice to the SSC saying that we have dropped the proceedings under the old notice, which was issued under the old act. Now, subsequent notice will revive. So, my lord, the notice which was issued under the old act, my lord, was deemed to be the show cause notice, and therefore it was revived under the new act.
All right. Then you do one thing. Then you produce copy of notice, small.
I have mailed it. I have mailed it. I shall send a copy to my learned friend.
Sir, let him get instruction next week. For the present, we can condone delay. 5 and 6, same order, delay condone next week. Next.
Same matter, my lord, delay is 288 days.
Yes, 7 and 8, same order. 9.
I don't know, 9 and 10.
72 days.
72 days. 9.
This is some. This one, Banerjee, that is some 2 children died.
Yes, my lord. Correct, my
Two
lord.
sons of the
Yes, my
appellant.
lord. Yes, my lord. My lord, actually, there was a previous order of the division bench which remanded the matter before the Hon'ble.
Correct. Chief Justice Prakash also saying
Yes,
that such a short order should not have been passed.
My lord, thereafter, my lord, a short order has been passed referring the matter to the CID. My lord, as a ray of hope, we approach the CID that look here, these are the documents along with the relevant.
No, CID. Will you be satisfied if CID re-investigates the matter?
Yes, my lord. Entirely on the factual issue.
All
That
right.
is-
Today we will condone
Yes.
the delay.
Next
Who will
Friday.
appear for respondent? Mr. Siddiqui will appear.
Mr. Banerjee, Amitesh Banerjee appeared.
Amitesh Banerjee. Heard Mr. Bhaskar Prasad Banerjee, learned advocate for the petitioner, and Mr. Amitesh Banerjee, learned advocate for the respondent. There is a delay of 72 days in filing the appeal. We are satisfied with the argument set out in the affidavit filed in support of the petition, and delay in filing the appeal is condoned. list the appeal for admission, whatever date.
Next week.
Yes.
May I call
Then the item 11 and 12, both are TP matters. Pratyush, you are appearing, no?
Yes, Your Lordship. Mr. Om Narayan Rai is from the SSC from department.
But can we not admit it? SU method, TMM method, how to say all that in admission stage?
If I may humbly submit, Your Lordship, in this case, one of the issues raised by the department is violation of Rule 46A. But, Your Lordship, that point cannot be urged by the department because, Your Lordship, firstly, that opportunity, in fact, was given to the department. The issue of another method, cup method, Your Lordship, that was agitated before the TPO himself. Opportunity was given to the department before CIT appeals. They did not appear.
One thing, Pratyush, one thing, after the recent decision of Supreme Court, what Supreme Court says, TP issue, we are required to go into certain facts.
But they haven't raised the issue of perversity. They haven't raised the issue of perversity, Your Lordship. And Your Lordship, it's a legal issue nonetheless, whether cup method can be agitated
I think probably if we admit it and list it sometime in first week of October, we'll do a good TP issue.
I leave it to my lords, but in my humble submission, Your Lordship, the question which pertains to Rule 40.
No, definitely, it will take at least 2 hours. We'll have to definitely go into facts, and probably we'll agree with you. We don't know. Huh? So we'll admit it.
But humble submission would be that, Your Lordship, question as far as Your Lordship, only A may be admitted because Your Lordship, B and C, Your Lordship, the rule violation of Rule 46A was not one of the grounds agitated by the department before the tribunal itself, Your Lordship. And in this case, Your Lordship,
all right, we will admit question A. Someone, please tell Mr. Rai. So and so heard, so and so admit. You please tell our AR court which is page number.
Yes, Your Lordship. Your Lordship, this is page number, but Your Lordship, in the second matter, Your Lordship, there is an additional issue. In case of assessment year 12-13, Your Lordship, it's solely a TP matter. At page 9, Your Lordship, is question number A. And Your Lordship, with respect to the other matter, which is assessment year 13-14, Your Lordship, department has raised an issue pertaining to section 69A as well, Your Lordship. That, Your Lordship, would be question number D. So, Your Lordship, in the second matter, which is assessment at 13-14, in my humble submissions, Your Lordship, questions A and D may be admitted, Your Lordship.
All right.
Now, in the first matter, my lord, our specific case was, my lord, in the throughout the proceedings, my lord, the SSC following, my lord, one procedure. My lord, before the, my lord, the CIT appeal and, my lord, ITAT stage, they shifted to the another procedure. Now the problem is that the TPO did not, my lord, fix the umbrella price on the shifted procedure followed by the SSC. My lord, he has, my lord, taken the arm's length price, the procedure followed by the SSC. That's why, my lord, the ground number B has been taken. The tribunal.
All right, we'll admit it, sir. All right. We'll consider it. Yes. Give a date for the appeal in October first week or so.
Date.
You admit both questions.
But question A, my lord, in my humble submission would be for 12-13, for 13-14, A and D. D is another issue.
Someone wants B also to be admitted. We'll consider it. No problem. A and B.
Your Lordship, B, in my humble submission, that issue was before the TPO. He had the opportunity, even the tribunal records that fact.
So that you'll succeed after any.
I will not argue, my lord. I apologize, Your Lordship. I will not. I'll argue at the time of the hearing, Your Lordship.
Yes. That will be good. And the remaining matters, Saurav is there, 148. All 148 matters dismissed, and you are coming on appeal.
Right, Your Lordship.
Item number
We'll take it up next week.
My lord, Monday.
Because in one of the matter, my lord, of the same SSC, my lord had heard, and my lord, Your Lordship had reserved that matter for
that
party.
matter where Mr. Majumdar was leading me. My lord, we'll take it on Monday, my lord.
Yes.
Oh, we have reserved judgment.
Yes, my lord. For the
yes, the same SSC, my lord, Your Lordship had reserved that matter for pronouncement of judgment.
What is the APOT number?
187 of 2023. My lord is taking.
Then we'll do one thing. We'll adjourn this by 1 week.
My lord.
Item 13, adjourn to, you give a date.
Next Friday.
By then we have to deliver, no? The judgment.
My lord will give as per your lordship's convenience, my lord. Yes, it's our
1 week you give, 1 week.
My lord, 1 week.
The remaining,
My lord, even in the list.
Get full, my lord.
Number 14 to 18 even in the list, ma'am.
yes, 14 to 18.
Fine.
Okay, thank you.
Yes.
Thank you, Ramesh.
Before your lordship rises, may I make a request, your lordship?
Yes, Mr. Raf.
My lord, before the single judge, my lord, the difficulty we are facing, my lord, is that the hearing matters, my lord, are not being taken up because, my lord, all 5 days, first the motion is taken up and then the hearing matter are supposed to come. Now, my lord, even if they come on some days, say for half an hour or 40 minutes, all, my lord, the effort is going down the drain because then again it comes up probably 3 months, 2 months, and something like that. So, my lord, nothing is moving, my lord. So, may I request, my lord, if your lordship can assign, say, it is, my lord, I am making a request. If suppose, say, 3 days for motion or 2.5 days for motion, 2 days for.
I can't do that. And as a Chief Justice, I cannot say that a particular judge shall manage his board in a particular manner. But if your request is for constitution of one more bench, which can take up hearing matters, that's a different issue. But problem is already there is shortage of judges. And this season also, the health of everybody has been affected. As a result, to organize, I bear this in mind because I cannot say that you please do this in a particular way. That will not be possible. So I'll keep this in mind and try to do this. Okay.
Yes, my lord. If some my lord, because the hearing bench also one bench which your lordship has given for only hearing matter, there no few new listing, it is totally barred. So we cannot go there also. That is the problem.
No. This one, group 4, you need to have a separate hearing bench.
Yes, my lord. Yes, my lord. Yes, my lord.
There's huge dependency. Let us see what to do.
For last 1 year, my lord, except 1 or 2 matter, my lord, nothing has moved. So that is why it is creating a lot of difficulty for us.
Most of the matters you are on appeal, already dismissed, everything you are filing appeal. What to do?
Yes, ma'am.
We'll do something. Huh?
Great,
okay.
great.
Okay, thank you.
February